If a police officer arrests you and begins asking questions, what must they legally tell you? Many people believe Miranda rights apply in every police interaction, but that is not true. Misunderstanding Miranda rights can damage your case. This is Rights and Reality USA. We separate legal fact from Hollywood fiction, so you can protect yourself with knowledge. What police can and can't do changes when you understand precisely when Miranda applies. The Miranda rights originate from the 1966 Supreme Court case Miranda v. Arizona. They protect the Fifth Amendment right against self-incrimination. The court recognized the coercive pressure of custodial questioning. The 4 warnings are clear. First, you have the right to remain silent. Second, anything you say can be used against you. Third, you have the right to an attorney. Fourth, if you cannot afford one will be appointed. These warnings are required only during custodial interrogation. Custodial means a significant restraint on freedom, like formal arrest. Interrogation means questions or actions likely to elicit an incriminating response. Miranda requires 2 elements: custody and interrogation. Voluntary street questioning does not require Miranda. If you go to the station voluntarily, you're likely not in custody. Undercover officers do not have to read Miranda. Traffic stops are typically temporary detentions, not custody for Miranda purposes. Answers during non-custodial roadside questioning are admissible. If the stop escalates to arrest, custody begins and Miranda must precede interrogation. The line between detention and custodial arrest is the trigger. If you're free to leave, it's not custody. No warning required. Informal, voluntary interviews are not custodial. No perceived coercion, no Miranda. Failure to read Miranda does not automatically dismiss charges. It affects the admissibility of statements from custodial interrogation. Courts may exclude those statements from the prosecution's case-in-chief. Other lawfully obtained evidence remains admissible. Physical evidence discovered legally can still be used. A suppression hearing determines admissibility. Suppressed statements may still impeach a defendant who testifies inconsistently. The judge hears testimony and applies the law to specific facts. The government must prove warnings weren't required or that they were given and validly waived. If they fail, the statement is excluded from the case-in-chief. A waiver must be knowing, intelligent, and voluntary. Knowing means understanding the rights explained. Intelligent means grasping the consequences of giving them up. Voluntary means no threats, promises, or coercion. Simply starting to answer can be an implicit waiver. The act of speaking becomes the waiver. Silence alone may not stop questioning. You must clearly invoke. Ambiguous remarks like, "Maybe I should talk to a lawyer," are not enough. Use short, unequivocal phrases. Police can continue the investigation. They can use deception within limits. They can reapproach after time passes, consistent with constitutional rules. They cannot ignore a clear request for an attorney. They cannot continue questioning after a clear invocation. They cannot punish you for remaining silent. Violations lead to suppression. Egregious cases risk discipline or civil liability. Stay calm. Do not argue law roadside. That's for court. Clearly invoke your rights. Use short, unmistakable language. Stop speaking. Wait for your attorney. Document everything as soon as you can. Record times, locations, what was said, who was present, and badge numbers. Your memory can be pivotal evidence for your defense. Miranda rights protect you, but only if you understand when they apply. Silence is protection, when you invoke it clearly. Subscribe to Rights and Reality USA for more legal explanations. Next video. What happens after you're arrested? Step-by-step process. Knowing your rights is your right.